going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. Oh man, what was I gonna say? Oh, I just already wrote my intro. I am not feeling the best today, guys. So I apologize. I want to just apologize already. What is it? What's going on? This is Colin. Oh my gosh, what is? I'm blanking on my intro. Anyways, you guys want to watch some court? I want to watch some court. Let's watch some court. Oh man, sorry. Yeah, it's been a rough day. I've been under the weather, so we're gonna get through tonight though. Yay! All right, got a Judge Hesselink case tonight. This is a weird one. It's weird. It's wild. It's interesting. It's everything. So yeah, I don't really know how to explain it. There's a no contact order between. I don't know if it's husband and wife or boyfriend girlfriend. I don't remember the dynamic, but there's a no contact order, and the guy violates it over and over and over again. Yeah, it's fun. It's weird. Let's do it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
State of Michigan versus Ryan Schultz, file 25-43974-SM, set for a motion hearing today.
Judge, I just wanted to know, it looks like we have the Crawford County courtroom here. I don't know. Our hearing's going to have testimony. I'm not sure what they're here on.
Their hearing's going to have testimony too.
Oh, okay.
I'm assuming so.
I'll stay out of it then.
Am I incorrect in Crawford County?
It's not anything I'm involved in, though.
No, it's
right.
it's one of their matters that I've been assigned to. They're just going to be recording for me, and they'll just have to wait. All right, we're here on the Schultz matter. There are competing motions to either revoke bond or to set aside the no contact provision of the bond. I'm going to let the prosecution go first as to their motion. Then Mr. Sandfield, you can go first, next as to your motion. Ms. Brucker, do you have any opening statements that you want to make, or do you want to just get to the testimony?
No, Your Honor. I just wanted to make sure everyone has. I sent out before the last hearing some exhibits. So we're all following along together. I want to make sure everyone has them. I set out one that was labeled Exhibit 1 that consists of 2 pages. Another one labeled Exhibit 2 and has a number of pages of text messages. The last one, I don't think I put a number on, but there's a People's Exhibit sticker and it has some photographs on it.
Judge, I don't know if I put my name on the record, by the way. Good afternoon, Judge. My name is Gary Sandfield, counsel on behalf of the defendant.
Thank you, Mr. Sandfield. My apologies for not letting you put your appearance on the record. I do have those documents, Ms. Brucker.
Okay.
Mr. Sandfield, I have proposed exhibits, I believe, from you, at least we're connected to your, I have a long list of, looks like screenshots of Facebook or something along those lines. So I have those as well attached to your response to the people's emergency motion to revoke bond. Is there any other documentation that I should have, counsel?
Not in front of you, Your Honor. I have a couple of recordings that I'll play, but as far as printed documents, that's all I have.
We don't have anything additional. Well, I can't think of anything additional at this moment.
All right, Ms. Brucker, do you wish to proceed, or would you proceed at this time, please?
Yes, Your Honor.
Judge, before Ms. Brucker, may I make a brief statement regarding where we're at on this today before we move forward on this bond violation?
You feel you must.
Well, what happened, Judge, is it's my understanding that the complaining witness does not really want to pursue the bond violation, but rather is being encouraged to do so by maybe an overambitious prosecutor and or crime victim.
Mr. Sandfield, I find that to be totally useless argument.
Okay,
Whether the prosecutor is ambitious or not, she has the right to bring whatever she wants to do in a criminal case. So your whining about it isn't going to do anybody any good.
all right, sorry about
So
that.
you got anything else that you want to bring to my attention?
Not at this moment, thank you.
Thank you. Ms. Bruker, please proceed.
Your Honor, my first witness is Sarah Mirror, and she is here on this Zoom. I'd ask the court to swear her in.
Ms. Mayor, would you raise your right hand, please, so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you very much. Ms. Bruker, your witness.
Okay, ma'am, could you just say your name for the record and spell your last name?
Sarah Mehrer, Mehrer.
And do you know someone named Ryan Schultz?
Yes.
And how do you know him?
We've had a 5-year relationship and we share a child.
Okay, and you are a witness and victim in this domestic violence case that's pending, correct?
Correct.
Okay, and we're not going to get into the substance of that case today, but we're going to talk about the bond right now. I wanted to direct your attention specifically to January 29th. Do you recall that date?
I do.
Okay, and did we have a court hearing on that date?
Yes.
That you recall? Okay. After that court hearing, did Ryan Schultz have some contact with you?
Yes.
And can you describe what that contact was?
I was upset about his lawyer asking to postpone everything just because you weren't there and to lift the no contact. And then I texted him and said to not call me or text me. And then he did continue texting me and calling me.
Okay. So he sent some text messages on January 29th and after January 29th.
Right. Yeah.
Sorry, I couldn't, it kind of broke up. I couldn't understand.
Ms. Bruker, could you repeat that question? Because it did not come through clearly.
Okay, I'm sorry. So you received some of those communications from him on January 29th and after January 29th?
Yes.
Okay. Did he also leave you any messages on your phone after that date or on that date?
Yes.
And what type of messages did you receive from him? Are these text messages or voicemails? Could you describe?
I got both, and they were mostly just begging me to talk to him, give him another chance, stuff like that.
Okay. Can I have you look at some documents? Did you provide some documents to our office and some recordings to our office?
Yes.
Okay. Do you have in front of you a stack of messages that's labeled People's Exhibit 2?
Yes.
Okay. So I'm going to just scrolling through those. Are those messages that you provided to our office that were exchanged between you and Ryan?
Yes.
Okay. Judge, I'm going to ask the court to admit that exhibit, then I'm going to have her go through them and explain what it is.
Mr. Sandfield, any objection to People's Exhibit 2?
I would defer to your discretion, Judge.
I'm sorry, I did not hear what you said.
Our objection would be obviously the documents. I mean, there hasn't been a real good foundation for them. I mean, it's a thick exhibit, but I would rather she went through them first and then move to admit before and had more of a foundation, as opposed to saying, I have these proposed exhibits, I want to admit them, then go through them.
Ms. Bruker, you opposed to that?
I can do that, Judge. Since it's a bond hearing, I was kind of trying to go through this a little quicker than we would if we were in a jury trial or something like that, but we can do that way as well.
Thank you. Please go ahead.
Okay, Ms. Mayor, I'm looking at the first page, People's Exhibit 2. There's a document. It shows the name Ryan Schultz at the top, and it says requested your location. Can you describe what that is and why you provided that to us?
So he sent me his location and requested mine. And then he was having DoorDash come to the house and then asking to give him another chance.
Okay.
Um,
So that's something that he sent you through your phone, the requesting.
That always works, right? You know, when you're trying to get back together as a girlfriend, you just DoorDash him a bunch of food, right? But that's a good move, especially when you have no contact order, right? No, yeah, this guy, he doesn't understand what he's doing.
your location.
yes.
And why did he do that? Do you know?
Just to know where I was at.
Okay. Just going back for a moment, was there a time when the two of you resided together?
Yes.
Okay.
Up
And was
until
that,
mid-December.
and that was here in Otsego County.
Correct.
And then since December, you've moved to a different location.
Yes.
And where is that? Without, you don't have to give the address, but just say the general
Heartland.
location. Okay.
Livingston County.
Okay. So did you receive this message where he's requesting your location? Was that sometime after January 29th?
Yes.
Okay. And that was when you were living in Heartland, not in Gaylord?
Correct.
Okay. And then, so he sent you these other, where the text is in the black, those are messages from him to you?
Yes, that's right.
Okay. And then going to the second page of that, and I'm sorry, it's labeled page 3, but it's the second page of that exhibit. There's a blue text bubble at the top. Is that something that you wrote?
That's what I wrote immediately after the court hearing.
Okay. And then below that, there are some messages in black. Are those messages you received from him?
Yes.
Okay. And it looks like there are 8 of them. Would you agree?
Yes.
Okay. Going on to page 4, there's some more text that's in black. Are those also messages that you received from him?
Yes.
And then there's a photograph of a dog. Is that something you sent him or something he sent you?
He sent that to me.
And then the text below, is that something he sent you as well?
Yes, it is.
Okay. And page 5 looks like a continuation of that particular text, just with some additional text in the text stream. Do you agree with that?
Yes.
Okay. Page 6, there's some additional text at the top, starting with, "Can you stop doing this, please?" Are those texts from Ryan to you?
Yes.
Okay. And then it looks like there's a video that was sent to you. Is that something he sent you as well?
Yes.
And then the text below it is also from him?
Yes.
Okay. Page 7 looks like a continuation of those text messages from page 6. Would you agree?
Yes.
And those are all from Ryan to you?
Correct.
Okay. And then page 8, just one moment. There's some additional text in the black. Those are from Ryan sent to you?
Yes.
And on all of these pages that we've gone through, next to the text message, there's a time next to it. Is that the timestamp for the time that you would have received those text messages?
Yes, it is.
Okay. And then looking at page 9, at the top, the name of it says Lana. Who is that?
That's Ryan's sister.
Okay. And then there's some text messages in black. Were those text messages that you received from his sister?
Yes.
And do you see the top one? It says Ryan, Colin, and then there's some information. How did you take, what did you think that meant, receiving that from her?
She was passing along what Ryan wanted her to tell me to see if I would respond.
Okay. And it looks like some of the messages are about your child, but some of them are about other things. Would you agree with that?
Yes.
Okay. There's some blue text on there. Are those messages that you sent back to her?
Yes.
Okay. And page 10 also just looks like a continuation. Would you agree, of some of those text messages? And at the bottom, there's another text that starts with Ryan and a colon as well. Do you agree with that?
Yes.
Okay. And then just looking at page 11, would you tell us what that is, what the significance of that is?
That's my call log, just showing the repetitive missed calls.
Okay, so where it says Ryan, those are time, and it's in red, those are times that he called you?
Correct.
Okay, and the timestamps next to it would correspond with the times that you received those calls?
Yes.
Do you happen to know what date you received those calls? If that was after January 29th or before?
Those were after.
Okay. And on any of those calls that he sent you, did he leave voicemails?
He did.
Okay, and did you forward those to our office as well?
I did.
Okay. Judge, I'd like to play for the court a few of the voicemails that she sent us. And I'm sorry, let me go back. I'd move for admission of People's Exhibit 2.
Counsel, objection? I'm sorry, Mr. Sandfield, you're on mute.
Could I just voir dire her real quickly?
Briefly.
Ma'am, are those text messages that you were just referring to, are those true and accurate of what you received from Ryan?
Yes.
Okay. And are there any text messages in that package also that you sent to him?
Yes. The ones that I confirmed.
Okay. And also, now this package, there were other text messages within this package that you submitted on those dates in question. You just didn't submit them as part of this exhibit. Is that correct?
I'm not.
Judge, could you
I'm not
rephrase
sure
that?
what
Could
you're
you have him
saying.
rephrase that? I'm not sure she understands.
Let me-
I know
let
what
me
he's
try-
asking her. I'm not sure she understands what he's asking her.
Let me try to rephrase it. Now you're submitting these on these dates and questions that are on those messages, but you're not stating that there were other dates within that time frame that you communicated with Ryan. They're just not attached to this exhibit. Is that true?
No, everything that I had sent when I sent them was the full amount of communication both ways.
Okay, so there you didn't delete anything that where you might have requested him to come over or to contact you. You didn't delete anything like that?
Correct.
And did you delete anything from his cell phone that were text messages that you sent to Ryan, but then at some time you got a hold of his cell phone and deleted those text messages? Is that true?
I think I'm going to object to that question because it's a multi-part question. And I think it's beyond the scope of voir diring this particular exhibit.
Well, it could be, Judge, if we're gonna say this is accurate and that he has all these communications, if this time it's not really fair to admit this document if it's not complete and if there were other communications, but this witness took an opportunity to erase those so that my client was devoid of the opportunity to present those items.
Certainly let you explore that on cross-examination. I don't know that it goes to it might go to the weight of the document, but it does not go to the admissibility of the document.
Okay, very well.
Anything else you want to voir dire on?
No, Judge, thank you.
All right, Ms. Brucker, are you renewing your request to have this document admitted, exhibit
Yeah.
number 2?
That was a long way around that question. I think most of us understood what he was trying to get at right away. But he asked, I don't know, 10 questions when that could have been 10 seconds. Could have just been one question. Did you send the complete text history or did you cherry pick some of them? Done.
Yes, Your Honor.
Exhibit 2 will be admitted. Any other evidence that you want us to adduce, Ms. Brucker?
Just a few other things. I'd like to play for the court a few of the voice messages that she received during that time period.
Any objection, Mr. Sandfield?
I haven't heard them yet, but I'm assuming that as long as they're accurate, we don't have an objection. I mean, I haven't heard what they are, so it's tough for me to say if I can object or not.
I think we sent them to you, or we at least made you aware that they were available.
Ms. Brucker, if you could have the witness identify what you're in general, where they came from, when they were made, who's on them, that sort of thing.
Okay. Yeah, doing this over Zoom is a little more difficult than we would do these in person. Miss Mary, you sent us a number of voicemails, correct?
Yes, I did.
And do you recall approximately when you sent those to us?
I'm looking right now. January 31st.
Okay. And do you recall when you received those voicemails?
They were from January 31st.
Yes, Captain Science. Yes.
Okay. Were there 4 of them?
Yes.
Okay. Those are all, so those are all what you would receive.
Oh yeah, we get to hear them. I don't think they play all 4, but I know they play at least. I think I remember hearing 2. I don't remember hearing 4, but like I said, I'm not feeling that well, so I was kind of in and out of this hearing this afternoon.
January 31st then.
Yes.
Okay. Judge, I'd like to publish those for the court.
Who are they from, please, ma'am?
They were from Ryan to myself on
And
my
is-
cell phone.
Are those the only 2 persons that are recorded on those messages?
Yes.
All right.
And
Mr.
I'll ask
Sandfield
her-
now?
I was going to ask her one more question. And
Go
how do you
ahead.
know those? How do you know those voicemails were from Ryan?
They came from his number.
Okay.
And I mean, I know his voice.
Okay.
Now, Mr. Sandfield, do you have any objection?
Not at this time. I might want to renew something after they come in. Also, Judge, I know this is somewhat informal, but I was just asked that the prosecutor try to refrain from asking every question as a leading question.
All right. You may go ahead and play the voicemail messages, Ms. Brugger.
Okay.
Those will be admitted.
I'm just trying to quickly remember how I share my audio on Zoom. We've not done a.
For me.
Oh, I know. I did. I was all tested out for our last hearing, and we've not done an evidentiary hearing on Zoom in a very long time.
Just all this evidence is terrible for his case. So once he doesn't want any of it in. I don't remember how long this takes. I don't think this takes too long. Hey, what's up, Aaron? You haven't really missed a ton yet. Yeah, you haven't really missed anything too juicy yet. It's about to start getting juicy now with the voicemails. Wait, did the video freeze? No one's moving. It says it's running. What's going on here? Is it frozen for you guys too? Or is this just on my end? It's frozen? Okay. All right, I just skipped ahead and skipped back. I think that fixed it. I don't know what was going on there.
Let me try this.
Yeah, I think we're good now. That was weird.
Judge, did you
Yep.
hear? Did you guys hear that?
Did not.
I wonder if I'm not equipped to do that. There's not a setting or something that Mr. Horgan has toggled.
believe so.
Okay.
Just check now. Share screen.
All right, I should have cut this part out. Sorry, guys.
She should be able to.
I don't want to fast forward it because I don't
Far
want
as
to
we
fast
can
forward right in
tell,
the middle.
Okay.
Everything's enabled. Yeah.
Let me try it on a share screen then. Oh, I can do share sound. I just saw that. If I pull that up again, I can do it on share sound. I just saw it pop up and it disappeared. Okay.
Sarah,
Can you hear that?
Yes.
That wasn't working.
I feel like I'm just annoying the fuck out of you now. Please talk to me. Please. Please talk to me. I can't do this. Can't do this. Can't do this without you. Cannot fucking do this without you. I cannot. I love you. Please don't make me do this without you. Please. Please. I love you so goddamn much. I literally cannot be without you. I don't give a fuck. Nothing matters. Like, I don't want to be anywhere in this world without you or without the girls. Please. Please, please, please. Let me fucking get through this with you. Please. Please, Sarah. I love you. Please. Please talk to me. Please. I love you. I miss you so fucking goddamn much. Please, Sarah. All I want is you. I want to make you happy. I want to fucking, like, please. Please. Please.
Okay. Miss Mayor, were the other 3 voicemails you received pretty similar to that as far as the contents of them, as far as you recall?
I would assume so. I don't really remember, but
Okay.
And
I'm sure they were all along
I'm
those
gonna
lines.
object to that question, Judge. You can't ask a question like, for something that's not admitted into evidence, is that the other stuff the same? If
Well,
you-
I was trying to expedite so I don't have to
Yeah,
play
it's
all
better
4
play
of them,
them.
but I can do that if that's what's, you know.
I'm not
needed.
I'm not asking that they be played. I'm just asking that you can't ask her a question about something that's not admitted into evidence and saying, is that accurate?
Okay, Mr. Sandfield, the rules of evidence at a bond hearing don't apply. So I'm trying to give you the benefit of the doubt, but it's 20 minutes to 4. We've been at this for 20 minutes. I think I understand where we're going with this.
Okay.
So let's just get it through it.
All right, I understand, Judge. Thank you.
Moving on quickly, Ms. Mayor, there's another exhibit. It's marked People's Exhibit 1, and it looks like a map. Could you pull that up and look at that? Tell me you have that in front of you?
Yes. Okay, I do.
Okay. Is that something that you provided, those 2 pages attached to that exhibit? Is that something you provided to the prosecutor's office?
Yes, it is.
And why did you provide that? Can you tell me what it is, I guess, first? Describe what that is.
So the blue dot is myself at my new residence, and then the other little gray circle with a person is Ryan, parked down the road from my house.
Okay.
Just camping out when I was telling him not to.
Okay. The second page, is that just a zoomed in version of the first page?
Yes.
Okay. You said camping out when you were telling him not to. Can you elaborate on what that means?
He was sleeping in his car in a park multiple days in a row.
That proximity from where you live now?
Correct.
And he does not live at that residence where you live now, and he never has?
No.
Okay. Is that like a screenshot that you grabbed from like a Find My iPhone or something like that? Or how did you get this?
He has periodically sent me his location and then unsent it, trying to get a response. And when he sent it at one point in time, I took a screenshot of it before
Okay.
it was unsent again.
So this is that screen.
This guy's a genius. Michael Dennis, sorry I missed your milestone. I apologize. I don't know how I missed it, and I just saw you did it. So thank you. Hopefully you're still here, and thank you so much for the 20 months. I appreciate it. Thank you.
Screenshot that you took.
Correct.
Do you recall when the date of this was?
I don't.
Was it after, was it after January 29th?
Yes, it was.
Okay. Moving on, there's a last exhibit. It's not late. I'm sorry, Judge, I'm going to move for admission of that exhibit, exhibit 1.
Objection, Mr. Sandfield?
Judge, I would defer your discretion as to the weight. Obviously, it's probably admissible, but I'd leave the weight up to you, up to the court.
Exhibit 1, both pages are admitted.
Okay. Moving on, Miss Mary, to the last exhibit. It's not labeled, but it's 2 photographs. I'm going to call it, I'm sorry, it's a number of photographs. I'm going to call it exhibit 3. Could you pull up that in front of you?
Is that one that
It has that picture of a vehicle and there's a timestamp in the bottom corner. It's a dark picture.
Oh, mm-hmm.
You have that in front of you?
Okay.
Otherwise, I can screen share.
Okay, could you screen share it?
Yes.
Thank you.
Do you recognize that picture?
I actually wasn't sure what that one was.
Oh, okay. So we'll move on from that. I'm going to move to
the one from the camera. Mm-hmm.
Okay. I'm going to mark that picture as exhibit 3. You recognize that picture. Could you tell me what is in this picture, what it's depicting?
It was Ryan parked at the house in Gaylord.
Okay. And why did you send that picture to us?
He was not supposed to be going back to the house yet. I had still not gotten all of my things moved out of there, and he had called and asked the police if he was allowed to go there, and they told him he would have to get permission from the court to do so, which he didn't do. And then when he wasn't getting a response from me, he went there and like broke his way in, to knowing I would see it on the camera, hoping that I would respond.
Okay. And so when was this picture taken? Was it prior to you moving to Heartland, or?
She already said, Judge, that she'd already moved, but she had some things left in the house.
Well, I was
Ms.
still
Brooker gets
in
to ask the
between
question.
both.
So hang on. Ms. Brooker gets to ask her question. The witness gets to answer. Go ahead. Give me when it was taken.
It was after January 29th.
Okay. And is there some kind of like a surveillance or a ring camera that took that photo?
Yes.
Okay. And is that a screenshot of it?
Yes, it is.
Okay. This next picture, can you tell me what that is? Is that another one where you weren't sure what it was?
That's correct.
I mean, yeah. Can someone please explain to me what's going on here? You got 2 almost pitch black pictures and one was snow. Okay. Yeah, Jed, I figured you'd recognize this one. Jeez.
Nothing
I
on my
don't know what
screen.
that is.
My screen's just a black square.
Okay. All right, we already did that one. I will stop sharing. I'll move for admission of Exhibit 3, just that one photograph.
No objection.
All right, Exhibit 3 is admitted.
I just have a couple of other last questions for you. Ms. Mayor, has Ryan essentially continually had contact with you by text message throughout the duration of this case?
I'm going to
Yeah.
object to that. That's overbroad. And also the motion to revoke bond has got specific dates in it. And also, Judge, there was a previous motion to revoke bond, and that motion was dismissed, and that had dates in it. So to paint with broad strokes like that would be overbroad and inappropriate.
I don't know that a bond motion, other than giving notice, has to be specific as to the dates upon which each particular incident occurred. Can you cite me some authority for that, Mr. Sandfield?
Obviously, I don't have that at my fingertips, but I just know that we have a right to know what the issues are so we can prepare for the hearing. And the issues were identified in plaintiff's motion stating on certain dates and times certain activities occurred. And now to go back to, I think this case starts in July, is not really putting us on notice of what's an issue since July. But more importantly, Judge, up until this hearing, the bond motion before that, which had all these dates in it, was dismissed. So it was so that those dates really don't seem to be an issue on this motion.
There was no determination of the basis of the previous motion. The bond motion the prosecution has made now, entitled its emergency motion to revoke bond, talks about January of 26, over the weekend in January to early February of 26, and then also October of 25, September of 25. So it clearly is for a number of months worth of period of time. I find no objection there. You may continue, Ms. Bruker.
Was there a prior time, Ms. Mayor, that you had made a report of a bond violation to the Otsego County Sheriff's Department while you were still living in Gaylord?
Yes.
And can you describe what you believe what the bond violation was?
There was the ones from September, and then I believe the other ones were December.
The one in December, would you describe when you reported that to the Sheriff's Department and they took a report on it? Would you just describe what happened?
He was at the house. He had been there for multiple days, and then I was telling him I wanted him to leave, and he was swearing at me, calling me a bunch of names, and I said that I was going to call you if he didn't leave, and then he finally did leave, and he got pulled over right outside the driveway and told the cops that he was just there to drop off or pick up our daughter, and then they ended up letting him go.
Okay. You're having some difficulty, I know, remembering some of the dates. Is that because he's been continually having contact with you throughout this case?
Yes.
Okay. Has there been a time during this case when there's been any period greater than a day or so when he's not had contact with you?
No.
Okay. And generally, is the contact that he's been having with you since, and I'm just narrowing it to January 29th because I think that's a good benchmarker. Has it generally been over text message and phone call?
Yes.
Okay. Has he been to the residence at Heartland where you live?
Yes.
Okay. And how many times has he been there?
Like 5, maybe.
Okay. Is there anything else you'd like to inform the court of regarding the bond violations?
I'm going to object to the question being overbroad. Also,
Mr. Sandfield, we've been over this once. Why do we need to go over it again? There's no evidentiary rules at a bond hearing.
All right, Judge, I'm sorry. I'll
I mean,
withdraw.
I'm trying to give you every benefit of the doubt, but come on, man, it's going on 4 o'clock. We got things to do. I got another court hearing after this.
All right,
Let's get
okay.
to the meat of the matter and be done with it.
All right, I understand.
Go ahead, Ms. Bruker.
Okay. Did you have anything else you'd like to inform the court of regarding the bond violation, Ms. Mayor?
I do not.
Okay. Judge, that's all I have.
Thank
Judge,
you.
I
Mr.
have
Sandfield, cross-examination.
Man, he was just about to interrupt the judge. Like, I got questions. Yeah, we know. We know how this works. I think we know how it works better than you do. Chairman Juro, thank you for the super chat. I appreciate it. Colin, please delete my voicemails from 2 a.m. Never. Those help me through my day. When I'm feeling a little low at 2 o'clock, I listen to that voicemail and it perks me right up. Thank you so much for the super chat. It's frozen again. Every time I pause, it freezes.
Thank
Judge,
you.
I
Mr.
have a few
Sandfield, cross-examination.
Judge, could I take just a real quick moment to use the bathroom, and I'll be right back because I've been sitting for a while. I need to run to the bathroom. It'll just be a second. Can I take like a 2-minute break, please?
Yep.
Thank you.
All right, we are back on the record in the state of Michigan versus Ryan Schultz. Mr. Sandfield is back with us after taking a short break. Mr. Sandfield, I believe that you wanted to say something and then you're ready for cross-examination.
No, I'm just going to go into the cross-exam if I could.
Go right ahead.
Thank you. Ma'am, you stated that on that last police report you made, you said it was because you asked Ryan to leave after he was at your residence for multiple days, and he didn't leave this at the moment you wanted him to leave. Is that correct? Sarah, you have to unmute.
And that's from the one in December.
I'm talking about the one where you called the police and said he was at your house for multiple. You said he was at your, when the prosecutor said to you, why did you call the police on that day? And you said, because Ryan was at my house for multiple days and I asked him to leave. And so that's the reason you made the police report, but you didn't say why. Is that because you say he didn't leave when you wanted him to?
I did call.
Pardon?
I did call them. I don't understand what you're asking me.
Well, I'm saying, why did you call the police?
In December,
Yes.
because he was at my house up north and he
No,
wouldn't leave.
I'm not talking about that one, the picture of his vehicle.
That's the one you're referring to, though.
I'm referring to the time you said that you made a police report when Ryan was at your house for multiple days and you asked him to leave. Is that the one we're talking about?
Yes,
Okay. And we say multiple days. Were you there?
I was. I lived
So-
there. I didn't have a house down here yet.
Okay. So you were still living at the residence in Gaylord.
That's correct.
Okay. If he was there for multiple days, obviously you agreed to that and it was okay with you during that time frame, correct?
I'm gonna object to that. I don't think it matters. I don't think characterizing her as being okay with it is what the court's going to be deciding today. The court's simply going to be deciding whether or not he violated his bond by being around someone who was court ordered not to be around.
Judge, there's mitigating factors and there's more to this than just saying there's a technical violation. So I think that question is very appropriate.
I'll let you ask it.
Ma'am, so you consented to Ryan being there with you and living with you for multiple days, correct?
Yeah,
Okay, and during those multiple days, there were days where there were sexual encounters as well, correct?
no,
Were there days since this case started, were there any days where you and him engaged in sexual activities?
yes,
Okay, that was by your consent, correct?
yes,
And that was a time period when the no contact order was in place, correct?
it's still in place, correct.
And then when this no contact order was in place and the date he lived at your residence for multiple days, why'd you call the police? You used this, if he was there and by consent, why did you call the police? Because he didn't listen to something you wanted him to do?
I wanted him to leave. He had already been there multiple days, and I didn't tell him he could stay that long. He said he was going to be visiting our daughter, but then it turned into just badgering me whenever she was asleep about, let's just have another chance, give me another chance, blah, blah, blah. And I was
Biggin, thank you so much for the raid, my friend. I appreciate it. Welcome to everyone coming over from Biggin. Yeah, we're about halfway through this video. This is a bond violation hearing. This guy in the suit that's sitting in his car in the bottom left has been contacting his girlfriend, top right, pretty much nonstop for the last 4 months when he has a court order not to. Yeah, that's pretty much where we're at. His defense attorney's kind of annoying. Doesn't seem to grasp what he's trying to do. So that's been fun to watch. But that's all you've missed so far. It's about to get really good right now. And the pause thing again.
into just badgering me whenever she was asleep about, let's just have another chance, give me another chance, blah, blah, blah. And I was over it, done with listening to that every day. And I was like, I want you to leave. I want you to get out of here. Like, you're not even allowed to be here.
Okay, but you had consented for him to be there, right?
At the time, yes,
Okay.
I did.
So you used this no contact order when it was okay for him to be there at certain times, but when you decided you didn't want something to take place, you used the no contact order in that regard, correct?
I'm going to
If I
object to that.
didn't
It's
want him to
argumentative.
be
I'll
around
withdraw that
me,
question. I'll rephrase
Stop.
that question.
Stop. I can only have one person talking at a time. When Ms. Mayer is talking, nobody else is talking. When Mr. Sandfield is talking, nobody else is talking. When Ms. Brucker is talking, nobody else is talking. So, Mr. Sandfield, rephrase your question.
Thank you, Judge. So would it be fair to say that you were using the no contact order at that time to pressure Ryan into leaving the house because you decided it was time for him to go?
no, absolutely not. I would not say that that would be a fair thing to say. I didn't have to pressure him not to be there. He wasn't supposed to be there. I
Well-
allowed him to come visit our daughter, and then he was staying longer than we had agreed on.
How many days did you agree on?
A couple, and it was like 10.
He was living with you for 10 days before you called the police?
That's correct.
Okay. So obviously you're not really afraid of Ryan, correct?
At times, it depends on what's going on.
Now, haven't you told him in the past, while this case was pending, that you were really not afraid of him?
I'm going to
At
object to that. I don't
times.
think that's a relevant question for a bond violation.
I think it is relevant, Judge. It's a mitigating factor on a technical
Mitigating
violation.
factor to what?
To a
Whether
technical
she's
violation.
afraid of him or not, what difference does that make in a bond violation as to whether or not the court ordered him to stay away?
Well, Judge, the bond violation, a no contact order is designed to ensure that a defendant appears in court and that the public is safe at large and that the complaining witness in a domestic violence case is not intimidated or threatened. And I think it's a very fair question when somebody during a domestic violence case is allowed to stay with you for 10 days, then all of a sudden I want you out, so I'm going to utilize the power that I have to get you moving. I think that's a very relevant question. I think that I'm not going to give you my thoughts, but I think the question is something I'm asking the witness that I think, Judge, that she should be required to respond to that.
You're missing one of the key points to no contact order. What she just said, what she just testified to, is he was whining about having her drop this case. Give him another chance. It's what is that, witness interference? Yeah. Why didn't you comment on that?
Purpose of a no contact provision is also under the court rules MCR 6.106 D2M if it's reasonably necessary to maintain the integrity of the judicial proceeding. That's exactly why we don't want defendants and victims together, so that one is not, or is alleged to have not, used power or control to manipulate, intimidate, or coerce another witness. So you can go where you want to go, but I don't think it's going to do you any good today, Mr. Sandfield.
Okay.
So let's speed it up.
All right, I'll speed. Now, isn't it true, ma'am? You asked Ryan to put your name on the deed to his residence?
I'm not objecting to that.
ours.
I don't see
Yes.
how that's relevant.
Mr.
for this either.
Sandfield, come on.
Oh, Judge, I'm trying to just show you that there's no contact.
I can show you text messages over the
Stop.
course of
No,
our 5-year
stop.
relationship. saying
Stop.
that. Sorry.
Hey! Nobody gets to talk when I say stop. There are rules that need to be followed. One of them is do what the judge says. Mr.
I'm sorry,
Sandfield,
sir.
I get where you're going with all of this. You want to say that this is consensual behavior and that she asked for it. You've made your point. This whole hearing is without evidentiary rules. I get what you're doing. Why
Okay.
do you need to subject me to more of the same?
All right, I'm just going to ask her a few more questions. And with regard to my exhibits, I'm just going to ask her just, ma'am, you're not disputing the fact that you initiated contact with Ryan as well, correct?
At times, yes.
Okay. And then this gala, that picture, that number 3 at the house, you had already vacated that residence and moved into your residence in Heartland, correct?
No, it's not vacated. Over half of our belongings are still there.
But you weren't living there, right?
I was still going back and forth between both houses.
Okay. But Ryan was never there when you were there,
During what period of time?
when that picture was taken.
I was not there when that picture was taken. Ryan was.
Thank you. And I'm not going to go into all these exhibits because the judge has got a good picture of it. He's got a good handle on this. But you do agree that, did you review defendant's exhibits 1, 2, 3, and 4?
Of yours?
Yes.
I've seen some of them. I'm not sure if I saw 4
Okay.
of them.
You're not disputing that there's a multitude of occasions here that you did contact Ryan. Is that correct?
I'd have to see what they are.
Well, I don't want to spend this time going over all these. You just said there was. I'll go over the exhibit 1, starts off with, please water the plants right away heavily. The hibiscus takes about 10 orange cups of water and each other plant is 1 orange cup. Thank you. I appreciate it. Did you send him that text?
Yes, that was after he was not supposed to go to the house. He went there anyway. I saw on the camera that he was there. So I texted him asking if he could water the plants because I hadn't been there in a little over a week.
Right. You weren't living there at that point. You had the Heartland residence, right?
Yes, that's correct.
Okay. All right. So then you did text him telling him to water the plants on that day.
Yes.
Okay. And then in exhibit 2, the first page, do you remember sending him a text stating $1,800 is all of you paid last month? I don't care where you're coming up with the $6,000. Remember sending him that?
Yes.
Okay, it continued on the next line. So you can send something even if not the full amount I requested on Zelle. Otherwise, stop calling me.
Okay.
Does that mean if he pays you the $6,000, it's okay to call?
6,000.
If he pays you the $1,800 you were asking for, does that mean it's okay to call?
So we came up with our own agreement for child support, and he was paying me $3,000 a month. He had only given me $1,800 that month at that point in time. So he kept calling me, being like, please talk to me. And I said, send the rest of the money, or I have no reason to even get on the phone with you. You're not even going to pay your child support.
So because you led Ryan to believe that he paid his child support, he could be on the phone with you, right?
That's correct.
Yes? Okay.
Yes.
All right. So I don't take up all the judge's time because we're not disputing there's a technical violation here that there was some contact. But again, you agree too that you were not you were not threatened or afraid of him during these times where there was communication between you and him, correct?
I'm gonna object to that again. We kind of been through this already.
Ask your question. Let's be done, Mr. Sandfield.
Ma'am, during these times you were communicating with Ryan, is it fair to say that you were not afraid of him?
I'm gonna object to
Yes,
that, Judge. I
ma'am.
don't think, again, I'm not trying to belabor this, but I don't think it's a fair question to ask her.
What court rule states that a question is unfair, counsel? I've never
What's
heard
the
of
relevance,
an unfair objection.
Mr. Sandfield, what's the relevance to a bond hearing or whether or not the victim is afraid of the defendant?
Well, because one of the objectives of the bond here, strike that. One of the objections of a no contact order is protect a victim, an alleged victim who claims typically a lot of times they're entered to protect the victim because they're afraid of the defendant because there's an allegation of violence. I think it's quite obvious that that doesn't exist here, but I would just like the complaining witness to articulate that.
The court rule also cites, and I read it already and I'll read it again, MCR 6.106 D2M says that a bond violation of no contact is appropriate if it's reasonably necessary to maintain the integrity of the judicial proceeding. This case right here is exactly why we have no contact provisions, so that the parties are not sandpapering each other one way or the other or by both.
I understand, Judge, but I don't think there's been any effort.
No, I'm going to sustain the objection, move on, counsel.
Okay. So on some of these days, now you said earlier that Ryan didn't know where you lived at the Heartland residence. Obviously, you voluntarily provided that to him so he could stay with you during that 10-day period, correct?
I didn't say he didn't know where I lived. And when he was with me for 10 days, it was up north in Gaylord
Okay. Has he been
before I had Heartland.
but he's been to your residence in Heartland also, right?
Yep. We already talked about that.
You provide that address to him and that location, correct?
Yes.
And he stayed overnight there a few times too, didn't he?
Yes.
All right. Judge, I think you have the picture. I'm not gonna belabor anything further. I'm done. I have no further questions of this witness.
Thank you. Ms. Brooker, any additional witnesses or evidence?
Can I just ask her one quick question, Judge? It'll be quick.
Go ahead.
Ms. Mayor, Mr. Sandfield had asked you about some of the exhibits. Did Ryan send you any of those exhibits?
Yes.
Okay. So some of the text messages Mr. Sandfield's referring to, you had received those from Ryan.
Correct.
Okay. I don't have any other questions, Your Honor.
I do have one other question real quickly. Last time this case was scheduled, you failed to appear, and that was because it was based on information belief you didn't want to pursue the bond violation. And is it true that right after that, the prosecuting attorney sent
I'm going to object to this. I know what he's going to ask, and it's totally inappropriate. You know,
Mr. Sandfield, you don't get to question what the prosecuting attorney does.
Okay, let me
They have
rephrase.
absolute discretion to do whatever they want to do pretty much in a criminal case. They have the authority and the discretion to do that. You don't get to question them on that. They're not a party to the case.
All right, let me ask, I'll try to rephrase it real quickly. That after that, you failed to appear for that bond violation hearing, this most recent time, did 2 uniformed police officers appear at your residence?
I'm going to object to that because it's not relevant to this, and it's beyond the scope of a bond violation. I can, if the court wants information about that, I'm willing to do an offer of proof.
I don't. It makes absolutely no difference what the police did or didn't do.
Got you, Judge. Then I'm good.
Do you have any witnesses or evidence that you wish to produce, Mr. Sandfield?
Dr. Schultz, is there anything you would like to say? Or I'm of the opinion that you don't need to testify today. Are you okay with that decision?
Yes.
Are you
Would there
okay?
be anything that would be relevant to clarify with regards to what was questioned and asked, or not relevant?
All right, let me just, well,
Yeah, he's a dentist. He is a doctor. He's a dentist. They're going to talk about that here shortly. But yeah, I didn't want to. I didn't know if that would be spoiling it, but I wanted to put something like that in the title or the thumbnail, but then I decided not to.
I guess, can I make one comment about one of the things that was just said? I guess I have a few, but one thing would be that I had prepaid the child support.
Hang on,
3,000.
hang on,
Sorry.
hang on.
Sorry.
no, that
Mr.
doesn't, no.
Schultz, you don't get to make
Don't.
comments.
Okay. Sorry.
If you're
That's what I
gonna
was
tell
on.
me, hang
I'm
on,
not
if you're
gonna-
gonna
I'm-
tell me anything, it's gonna be under oath, subject to cross-examination. So it's either all or nothing. There aren't minor comments. So,
I'm
Mr.
not,
Sandfield, do
I
you
don't
have a
have any-
witness that you wish to produce?
No, Judge.
Closing arguments, Ms. Bruker.
I think, the court clearly understands the issues. We've had a no contact order in place since approximately, I think, August or so when this case was filed. Ms. Mayer testified that Mr. Schultz has repeatedly had contact with her throughout the case. We focused on the time period following the last hearing, just because we did, dismiss the other bond violation, and because right after that hearing, when the court again clarified with him he was not to have contact with her, he immediately starts sending her those text messages and calling her and leaving her voicemails and doing all of this other stuff. I've had probably 20 conversations with Mr. Sandfield. I'm not exaggerating. In every conversation, we talk about the no contact order and how his client should not be having contact with her, and yet we're here. So I'd be asking the court to revoke his bond. I believe this matter is on the trial track and is going to be set for trial.
Judge, 6.106 states for us that there's reasonable conditions to be put on bond, and also revoking the bond is the most aggressive thing the court could do. And the purpose of bond is, to a large degree, is to be sure there is an appearance for court hearing, and that the public is safe, and that the complaining witness is safe. I understand there's other provisions within that rule also for the integrity of the court and so forth, although I don't believe there was anything that was brought forth today that would lead the court to believe that those other provisions really are applicable. This is not a case, Judge. We're not talking about stalking. There was no intimidation. There was no harassment. This is just a serious couple and engaging in mutual ongoing communication regarding their relationship and their 4-year-old child. It's quite obvious that this woman is not afraid of Ryan because she allowed they lived together for 10 days. There were other occasions too. And she lived together for 10 days. And she's using this no contact order, not to protect herself, but as a control and power mechanism. It's okay for Ryan to stay in her house for 10 days and not have any problem with the no contact order. But the second she decides she wants something, she uses it for power and control. And that's where I wanted to go with it when you cut me off. I wanted to go show that she's done other things to use this, not because she needs it for her safety, but rather to manipulate Ryan into making payments and doing things. Otherwise, she will use the no contact to her advantage. That's not its purpose. Sure, we have a technical violation here. I'm not going to sit here and tell you that there hasn't been contact, but it's been mutual. It's been cordial. There's been no threats. There's been no harassment. There's been no intimidation. There's been mutual contact, and many times was initiated by the complaining witness, who's admitted that today. So yes, there is a technical violation to revoke the bond and say, Ryan, you have to sit in jail. We're not giving you any bond because you stayed with your girlfriend for 10 days, and when she told you it was time to leave, you didn't leave fast enough, so she's going to implement the bond condition of no contact. I don't think that's the purpose of it. So yes, we're going to state there's probably a technical violation, but there's a lot of things you can do to modify this bond condition other than revoke it in its entirety and place my client in jail He's employed, he's 40, he's essentially devoid of any criminal history. He's willing to even post an additional cash bond if the court feels that's appropriate. He's willing to meet terms and conditions just as long as it continues to allow him to maintain his employment. And I also think that, I know it's 4:30 and you want to leave, and I also think that the testimony you heard today falls within the parameters of my motion to remove the no contact order. So I'd ask you also to remove that, because you can see there's no need for the no contact order when the complaining witness allows the defendant to sleep with her for 10 days.
All right. Your Honor, my client's guilty. But can we change the rules so he's no longer guilty? Yeah, that's an interesting argument there. Yeah, let me use a phrase that I don't use enough anymore. It's about to go down. Judge Hesselink is about to just rip up these two. Oh, it is satisfying after sitting through this hearing. Sorry for the spoiler alert, but yeah, it's about to go down. Also, you know what? I'll explain that here in a second. I had a little technical error on this video. It's not my fault. It's the program I used to grab the cord. It kind of glitched at the end, and the video just completely paused, but we can still hear it. I'll explain that more when it happens, but we got about 30 seconds before I have to switch over.
Thank you, Mr. Sandfield. I know that the defense exhibits were not admitted, but I've read through the defense exhibits 1 through 4. I can find at least, I've got sticky notes on them. You can probably see them here on the edges. There's got to be a dozen different places where I wrote in the margins, emotional pressure, talking about how to resolve the criminal case. These are all messages that the defendant sent to the victim. Emotional and financial pressure, talking about the criminal case status, negotiating the criminal charges, or trying to specifically discussing the charges and the case disposition, and further discussing the case and changes and charges and trial. And these are in the defense exhibits. There are literally dozens, if not hundreds, of contacts that the defendant made to the victim. I get that the victim acquiesced in some of them. I'll even go so far as to say that she initiated some of them. But I have yet to see the volume that this case tells me of the defendant going out of his way to talk to have contact with, to pressure, to put emotional pressure on the victim in this case. This is classic power and control in a domestic violence case. There isn't any way to spin it otherwise. And I appreciate Mr. Sandfield's arguments. I appreciate the time and effort that he's put into those things. I get where he's going with that. I've been a prosecutor for 20 years. I've been a defense attorney for 15 years. I thought I had seen just about everything, but I have not seen this level. I don't even know what to call it other than chutzpah in saying no contact from August forward, no contact again in the hearing in January. And here we are arguing about whether or not it's okay for him because she said so. There isn't any okay from her. This is the judge telling you not to have contact, not because she needs to be protected. That may be one of the reasons, but because it's inappropriate to have contact between the parties in a criminal case so that there is no coercion, force, all of the things that go into this case that make.
I was muted. It's not over yet. So this is what I was talking about. My some weird technical stuff with grabbing this court, but I was able to go ahead and get the rest of it. But my compiler, for whatever reason, wouldn't compile the last part because the video glitches. So I had to do it a different way. I got it. The video does freeze, so we're not going to see any movement, but we're going to get to hear everything. So I didn't want to leave you guys hanging. All right, here we go.
All of the things that go into this case that make it such a struggle to get to where we are today. You don't get to create a mess out of the court system. And that's exactly what the defendant has done today. He has initiated, he has pressured the phone call that was played in, or the text message that was played in court today was him using emotional issues, please, whining and using emotional context to try to get her to do something for him. The defense exhibits that I reference are him emotionally trying to put pressure on her and talking explicitly about the criminal case. That's interfering with the criminal justice system. Quite frankly, you could be charged with a crime for witness intimidation. I mean, I don't know that you understand the depth of the stupidity that this whole bond issue generated. I can imagine a worse scenario. Could be a lot of violence, but for a lack of violence, this case is the worst bond violation I have ever seen. Mr. Schultz, where do you work?
Raylan Family Dentistry, Your Honor.
Where do you live?
I have been jumping around currently.
Nope,
but
not
my
going to do that. Where do you live? Where?
All right, he's about to give an address, so I'm just going to mute it for a second.
Gaylord, Michigan, Your Honor.
Is that the home that you share with the victim in this case?
Yes, Your Honor.
Ms. Brucker, is there any reason that she needs to be there at all for any purpose?
No, I don't believe so at this point.
I do have a residence in Royal Oak as well, Your Honor, if that's helpful for the interim currently.
I do need to still go.
Heck, no, I'm not listening to anything else. How are you going to be able to work if you live in Royal Oak?
I've been driving back and forth and staying at the hotel, been staying in the vehicle, depending, or at the house when I was allowed to.
No, I'm not putting you anywhere near her anymore. You may go from your home. Here's the bond conditions. You may go from your home to work and back, period. How long does it take you to get from your house to work?
About 30 minutes, Your Honor.
You've got 30 minutes from the time that you leave your house to get to work and 30 minutes to get back. What time do you work?
I work like 9:30 a.m.
Till when?
It kind of varies. It could be anywhere from 7 p.m. till like 9 p.m. If you have a cutoff time, I'll make it happen, Your Honor.
This is the boyfriend.
9:30 to 6:30.
So this is the boyfriend. He just happens to be a dentist. That's why he's testifying.
30. You may be at your work.
Judge, can I respond to that?
You may leave your home at 9 o'clock. You must be back in your home at 7 o'clock. If you are outside of your home, outside of those hours, you are going to jail.
Okay, Your Honor.
If you need food, or if you get it on the way home or get it on the way to work, if you need something more than you can get in a quick dash like that, DoorDash it.
Yes, Your
You
Honor.
are not to leave your house, period. Weekends included. You got 9 in the morning, you can leave. 7 o'clock, you got to be back. You will be in your home at all other times.
Yes, Your Honor.
You may not have any contact. I don't care what the context is. No contact means no contact. If it's you personally, if it's by computer, by social media, if it's by third parties, I don't care who it is. If somebody contacts them and says it's on your behalf, you're going to jail. You understand that?
Yes, Your Honor.
Oh, Cheshire Cat. Words are hard, Cat. Admit it, I'm your favorite cat name. Yeah. Yeah, I don't know. I like Cinnamon Stripper Cat too. That one might be my favorite. But Words are hard, Cat. That hits home. Also, I did miss this one. I didn't miss it. I just, I haven't announced it yet. But who was the Botox Queen? Oh, and hello all. That's girlfriend. That's girlfriend. Which I'm sure you found out by now since you sent that like 10 minutes ago. All right, we'll finish this up. We still have about 5 minutes left.
In case you haven't noticed, I'm not happy with you. You do not want to tick me off anymore.
Understandable, Your Honor. I'm sorry.
Do we need to put this on for jury trial as quickly as possible, counsel?
Judge, with regard to the 7 p.m., my client, a lot of times, he tries to make it at 6 or 7, but if he typically runs an hour or 2 hours behind if he has emergencies. So I know for a fact he sometimes runs till 9 o'clock. He's a dentist, and if he has emergencies or gets behind, it's impossible to predict an exact time. You can't stop a procedure and say, "Oh, by the way, I'll take the rest of your tooth out tomorrow." Would it be possible to extend that time frame a little bit to allow him to at least, address some problems that occur after 7?
Felix, no, she doesn't do Botox. She doesn't do that. Yeah, I don't know. It's a whole nother level of certificate and training she would have to do to be able to administer that. And I don't remember exactly what the answer was because I asked her that. I don't know, back when we started dating. So I don't really remember, but no, she does not administer Botox.
Counsel, that is a great suggestion. The only problem with that is he's burned so many bridges. I have no ability to believe that he will do that. In case you haven't figured it out yet, I don't believe a single thing that he says.
Could we push it maybe to 8 p.m., please?
No.
Okay.
The obvious answer to that is I could put him in jail today. Would you like me to do that?
Obviously, we're not asking for that.
I would hope not. So I'm being generous today now. This is me being generous.
I agree, Judge. I agree. You've been real fair with us. You've been real patient, and I'm not disputing anything. And even though I'm an out-of-town attorney, I think you're treating me with dignity and respect and giving us every break that you can, and I'm not disputing anything you just said. I realize for me, I've never been in this court before, so I mean, sometimes.
It's got nothing to do, Mr. Sanfield, it's got nothing to do with you. It has absolutely nothing to do with whether you're from this court or not. I just find these facts to be outrageous. And so I'm trying very hard not to put your client in jail.
Thank you.
So do we need to have a quick jury trial date?
No. We don't need to expedite this, do we, Dr. Schultz?
Whatever is convenient.
Okay. Could we do, Judge, like maybe a final pretrial? And I was going to ask you to set it out to May.
Why do we need to go that far out?
I'm hoping that a resolution can be achieved. Maybe I'm kidding myself.
I would hope that a resolution could be done as well, but we wait till May and then there's no resolution, I've lost 2 months doing nothing. This case has been pending since August of last year. We're already in March, so we're 7 months down the road. I'm supposed to have these cases resolved within 6. So you're already on my time clock. So I'm pleased to give you an opportunity to discuss resolution with the prosecutor, talk it over with your client. I'm happy to do that. But I need to have a resolution relatively quickly. I'm gone the next 2 weeks. We got time on the 9th or the 16th.
Yes, we have room on the 9th in the afternoon.
April 9th for another status review, 1:30 via Zoom. We're either going to have a plea or we're going to set it for trial.
Okay, thank you, Judge. That will be April 9th at 1:30 by Zoom.
Yes.
Perfect. Thank you, sir. Have a great 2 weeks off.
Mr. Schultz?
Your Honor. Yes, sir. Your Honor, if I'm not in Gaylord at the moment, do I need to report back there? I'm assuming immediately then, or am I able to go back at the end of the next couple days?
You got 2.5 hours to get home.
Okay. All righty. I'll make it happen, Your Honor.
Anything else, Ms. Bruker?
No, Your Honor. I don't think the court was considering this, but community corrections may have a tether available if the court's concerned about that as well.
You tell me if there's any further conduct or contact, there's going to be a jail order. So I know I don't need a tether. If he's dumb enough to do something like that, that's on him.
Okay.
Thank you. That's all for today. We're in recess.
Oh, Judge, with regard to my no contact or my motion, I'm assuming that has no traction. Or could we take another look at that on April 9th?
I didn't understand your question.
I filed my motion to remove the no contact order, and because of the time, we didn't really get to it. Could that be pushed over to April 9th, please?
No. The answer to your motion is denied.
Okay, I understand.
That's it. I think that's it. Yeah, no, that's it. That's where it is. The attorney asking. So we're gonna talk about this motion? Yeah, sure. It's denied. Okay, moving on. All right. Well, that's it. That's the video, guys. All right, hold on 1 second. All right, didn't want to cough in your ear. Yeah, this one was a wild one. This is so good though. Like it started off good. Like, it stayed pretty interesting during the entire thing, and then Judge was just done at the end. He's like, no, we're not playing this game. Anyways, thank you all for hanging out with me tonight. I do appreciate it. Biggin, thank you so much for the raid. You were awesome. And thank you for everyone that came over here. Mods, thank you for all your hard work as always. And let's see, super chats, membership milestones. Thank you so much. That's all I got for tonight, guys. Let's see who can raid. Let's see, it's 8:23. Is anybody on? I got nothing. Yeah, I'll go ahead and send us to Lone Wolf. I mean, he doesn't start till 9, but I don't have anything else live. Like no one's live right now, so I'm just gonna send you to Lone Wolf. You know, to blow up his chat before he starts. That's always fun to do. It also really helps your video if you have that much engagement before the video starts. But you know, do what you want. Have a great rest of your evening. I'll see you guys tomorrow at the normal time at 8 o'clock. Hopefully, I feel a little bit better tomorrow, so I don't have to, you know, try to jam a video together. I did barely watch it in court today, so luckily this gem came up. So yeah. Anyways, you guys are awesome. Have a great evening, and I will see you guys tomorrow. Okay, bye.